Welcome to the Deep Dive. Today, we're looking into a really fascinating and maybe surprisingly powerful role within government, the Solicitor General. We'll focus mainly on Australia.
Yes, and we've got some quite detailed source material to work with here. Looks like an academic work, actually. Acknowledgments, footnotes, the whole lot.
Exactly. So our mission today is to unpack what this often, behind-the-scenes legal figure actually does, why they matter, and how the role has evolved. We'll draw some comparisons, too, with the UK and the US where relevant.
And it's a role with a surprisingly long history, isn't it? The sources trace it right back to the 13th century in England, to the king's attorneys.
13th century, wow. So figures like Lawrence Del Brock, though his title wasn't quite attorney yet.
No, more like one who follows for the king. But these early figures were the precursors. Understanding that long journey from being the monarch's direct legal agent to, well, a more independent advisor is really key.
Okay, let's dig into that. Because they weren't the only legal advisors around, right? There were king's sergeants, too. Why did the attorneys become more prominent?
It seems over time, the attorneys just had a broader range of legal experience. The sergeants were often specialists, focused on particular bits of common law.
Right.
But as the state's business got more complex, that wider expertise made the attorneys more useful as general legal advisors to the crown.
And this eventually led to formal recognition.
Yes, in 1814, the Attorney General and Solicitor General were formally recognized as the heads of the bar in England. That really cemented their status.
But then things get complicated because these law officers started sitting in Parliament, in the House of Commons, after 1673. How did that square with being impartial legal advisors?
Well, it didn't easily. That's a crucial point. It created this inherent tension right away.
I bet.
You're expected to give independent legal advice, but you're also part of the political machinery. It's a balancing act that's been there pretty much ever since.
And the sources mention debates about whether they could have private practices and changes to their pay.
Exactly. Constant fiddling around the edges, trying to figure out the right model, how to ensure they focused on the crown's business, how to maintain that independence, or at least the appearance of it.
So when Australia's colonies were setting up shop in the 19th century, they looked to this British system.
Absolutely. Places like New South Wales, Van Diemen's Land, Victoria, they modeled their law officer roles very closely on the British practice.
What specific features did they adopt?
Well, key things, like having the law officers in Parliament, though usually not in the cabinet itself,
Okay.
giving them responsibility for legal advice and broader public interest functions, establishing the Solicitor General as the Attorney General's deputy, and crucially, that expectation of independent legal judgment.
And the need to get top people for the job.
Definitely. That was understood early on. These were and are vital constitutional roles.
There's an interesting story from 1878 where a colonial governor went straight to the English law officers for advice because he was getting conflicting opinions locally.
Yes, that really highlights the British assumption of independence back then. The colonial secretary basically told the governor to ask them because they were the authorized exponents of the law, not just political advisors.
Almost like independent judges of the law within government.
In a way, there was even a suggestion from Lord Carnarvon for a permanent and impartial legal advisor within the colonies, but that idea met local resistance. So the seed of independent advice was there, but it grew differently here.
Now, focusing just on Australia, the Solicitor General role didn't pop up everywhere once, did it?
No, you're right. In WA, South Australia, Queensland, the permanent SG role really only came about in the 20th century.
But the functions were being done earlier.
Yes, often by other officers. South Australia, for instance, had an advocate general way back in 1836 doing similar work.
Okay, what about the Commonwealth level? It's striking that the Constitution itself doesn't explicitly mention a Commonwealth Solicitor General. Why leave it out?
The sources point to maybe two main reasons. First, perhaps they just didn't anticipate the sheer volume of legal work the new Commonwealth would generate.
Underestimated it a bit.
Possibly. And second, there was likely that underlying British-inspired assumption that the Attorney General would be this impartial, top-tier legal advisor.
Even though, as you said, the trend in the colonies was towards attorneys general being more political.
Exactly. So there was maybe a bit of a disconnect between the assumption and the emerging reality here.
But the workload did grow. So
Yeah.
when did the Commonwealth SG office actually get created?
That happened in 1916. The Solicitor General Act, 1916, it was pretty much a direct response to that increasing workload.
And it allowed the Attorney General to delegate powers.
Yes, formally setting up the SG as the second in command for legal matters, able to take on specific duties.
The sources then talk about a modern period, starting in Victoria around 1951. What defined this period?
That Victorian move was significant. They created a quasi-independent statutory office described as council.
So a step away from the political side.
In some ways, yes. The source suggests it was kind of a return to that purely professional focus of the very early English law officers. Less politics, more law.
And did other states follow that kind of model?
Gradually, yes. In Tasmania, for instance, the AG's direct legal workload seemed to decrease over time, while the SG's responsibilities grew.
And SGs became known for specific expertise.
By the 60s, 70s, 80s, definitely, they emerged as real leaders in constitutional law, and often handled criminal prosecutions too, until dedicated DPPs came along.
Ah, yes, the Director of Public Prosecutions. The source mentions Tasmania getting rid of a rule where the SG would automatically step in as acting DPP.
Oh.
Why was that seen as not ideal?
Well, the quote is from a former Tassie SG who'd actually done it and basically said it blurred the lines too much.
Right, different roles, advisor versus prosecutor.
Exactly, and you need that separation.
We also see different takes on things like private practice. Queensland in '85 apparently considered letting the SG do private work. Seems like going backwards.
Well, their thinking then was it might help attract top senior counsel, let them top up the government salary. It contrasted with the trend elsewhere in Australia, where that practice had mostly starved.
Shows the ongoing tinkering with the model.
Absolutely. And you see pragmatic changes too, like in NSW, giving the AG clearer powers to delegate to the SG just to make things run more smoothly. Efficient justice administration.
Okay, let's tackle the big one. Independence. The sources call it myth and reality. That sounds complicated.
It really is. Independence is absolutely central, but what it means is debated. It's not just a state of mind, as the Canadian Supreme Court said in Valiente. It's also about objective guarantees, the structure, the relationship with government.
And even the punctuation matters. The hyphenation of Attorney General and Solicitor General.
Apparently, yeah. The source notes it's more common here and in NZ than the UK or US, maybe reflecting a slightly different conception of the relationship.
And then you had figures like Darrell Williams, when he was Shadow AG in the 90s, openly questioning how strong the Convention of Independence really was in Australia.
That definitely stirred the pot. It led to a lot of academic debate and public discussion. How independent is the SG really? Are they properly shielded from political pressure?
The sources lay out a couple of main schools of thought on independence.
Yeah, broadly two camps. One says independence is absolutely vital for good government, needs strong protection, almost separation.
And the other?
The other acknowledges the political context is unavoidable, but argues you can still achieve meaningful independence within that. Someone named Silkin held that view, apparently.
But others were wary of that view.
Yes, Edwards, another scholar mentioned, warned that Silkin's view could actually erode public trust if it looked like independence was being watered down.
Interesting. And there was even a third way proposed, Lord Shawcross.
Yes, Shawcross suggested something more radical, make it a completely non-political public service role, like total separation to guarantee independence.
But what was the counter-argument to that?
Accountability. Edwards again pointed out that a totally separate, unelected figure might lack democratic accountability. Who do they answer to?
It seems even the UK has had its own wobbles on this in recent times.
Definitely. The sources mentioned the BAE Systems investigation being dropped, and the advice on the Iraq War legality. Both instances raised big public questions about whether legal advice was being bent by political agendas.
How does the U.S. system handle this independence question? It seems quite different.
It is. The U.S. Attorney General is a very political figure, usually a close presidential ally.
Right.
But then they have the Office of Solicitor General, the OSG, which is generally seen as more independent, focused specifically on arguing the government's cases before the Supreme Court. And the Office of Legal Counsel, the OLC, handles a lot of the formal advisory work, so they kind of split the functions.
So where does the Australian SG sit on this spectrum?
The Australian model, particularly the Commonwealth one, seems designed to be outside day-to-day politics. It has a statutory basis, aiming for both actual and perceived independence in its legal functions.
So appointing legal experts rather than political players.
That's generally been the trend, yes. trying to get highly respected lawyers, which harks back to that early English idea of the expert advisor.
Okay, let's shift to the specific functions. Representing the government in court is obvious, but it's much broader than just advocacy, isn't it?
Oh, absolutely. The advisory role is huge. They advise the government as a whole, sometimes individual ministers or parliamentarians, and they have this wider public interest function, too.
And they're often the only legally qualified ministers, at least by convention in the UK now.
That's right, particularly after the changes to the Lord Chancellor role in the UK in 2005. It makes the law officers absolutely central for legal guidance within the executive.
When would the government typically go to its law officers for advice in the UK? What triggers it?
The list is quite broad, according to the sources. Things like really important or legally difficult questions, issues with major policy or PR implications, high-stakes court cases,
That's
also constitutional or international law matters, anything likely to go to cabinet, legal problems with a political angle, and settling legal disputes between government departments.
And the confidentiality around that advice is fiercely guarded in the UK.
Extremely. It's not just that the advice itself is secret, but often even the fact that advice was given isn't disclosed. And crucially, it's the law officers themselves, not the government client, who have to agree to release it.
Why so strict?
The idea, going way back to Lord Palmerston in 1865, apparently, is that it encourages them to give completely frank, maybe even overly cautious, advice without fear of political fallout. There's even a law officer convention where Parliament generally doesn't demand to see it.
But Australia seems to have tested that convention a bit more. The sources mention Maurice Byers in '75 and Pamela Tate in 2007 being called before Parliament.
Yes, those incidents definitely highlight attention here. You have Parliament wanting to scrutinize government actions, needing information, versus this principle of legal professional privilege for government advice.
So, differing views on whether releasing advice helps or hinders scrutiny.
Exactly. Does more transparency lead to better accountability, or does it make advisors less candid? It's an ongoing debate.
The sources also bring in this concept of integrity in government, linking it to the law officer's advice. What's that about?
It suggests the SG's role isn't just about is this legal, but also about broader principles, ethical considerations, public interest, the overall integrity of government action. Their advice can, or perhaps should, touch on those deeper aspects.
And the title, Counsel for the Crown, that captures both sides, advocate and advisor.
Precisely. It sums up that duality. Acting on instructions when advocating in court, but offering independent interpretation when advising. It's where that independence tension really plays out.
But who exactly is the Crown? The sources suggest it's not always simple, like with independent agencies or advising governors or governors general.
Right. Theoretically, it's one entity, but in practice, different parts of the Crown can have different interests, potentially creating conflicts for the SG.
Like advising a governor general on reserve powers. That could conflict with the government's view.
Potentially, yes. There's academic debate about whether vice-regal officers should be able to get advice directly from the SG in those tricky situations, bypassing the government ministers.
And some places have actually set up ways for that to happen.
It seems so. Recognizing the unique constitutional spot governors and GGs are in, some jurisdictions have created protocols for them to access SG advice directly if needed.
But generally, the main client is the government of the day.
Yes, the executive, acting through the Attorney General. That usually means limiting advice to other agencies to avoid getting tangled in conflicts.
And the advice the SG does give carries enormous weight within government here, described as holy writ sometimes.
That description comes up, yes. It's often seen as a constitutional given. There have even been resignations, apparently, when governments haven't followed the SG's advice.
Is there a legal obligation to follow it?
Not usually a strict statutory one, no. But the practice, the convention, is very strong. It's generally followed.
But the SG isn't the only lawyer advising the government, except maybe in the ECT and TASI.
Correct. In most places, they don't have a monopoly. The SG tends to get pulled into the really big stuff: constitutional law, public law, whole of government issues, politically sensitive files, making the big calls on new or tough legal questions.
It's a bit worrying, though, to read about SGs being frozen out sometimes. Robert Ellicott's experience is mentioned.
Yes, that's a sobering point. It shows that even someone in that position can be sidelined by bureaucratic politics or personality clashes. Good working relationships are clearly important.
The SG also helps the government achieve its policy goals, but within the law. The Mabo response is used as an example.
That's a key example. The Commonwealth SG at the time, Gavin Griffith, helped frame the Native Title Act as a special measure under the Racial Discrimination Act, finding a legal pathway for the government's policy response.
But there's debate about how much policy should influence the legal method.
Yes. Should the SG just find the best legal argument for the government's goal, or maintain a more detached legal perspective even if it makes the policy harder to achieve? Different views on that.
What about when the law itself is murky or unsettled? How does the SG handle that?
The approach described by former SA Solicitor General Chris Caracas is basically to lay out all the arguments for and against and assess the risks of each option. Then the government, the accountable minister, has to make the call.
The idea of core government principles also comes up: rule of law, parliamentary sovereignty, etc. How do they fit in?
They provide a kind of bedrock for the advice. It's not just about the letter of one statute, but how proposed actions fit with those fundamental principles of our system: responsible government, judicial independence, federalism, and so on.
And finally, the advocacy role. How do they balance being the government's hired gun in court with their duty to the court?
It's a classic lawyer's ethical tightrope, really. You argue your client's case forcefully, but you absolutely cannot mislead the court. You have overriding duties as an officer of the court.
The sources mention times the Commonwealth didn't intervene in high court cases challenging federal laws. That seems counterintuitive.
It does raise questions about whether there's an absolute duty to defend government power. Maybe sometimes the government decides, perhaps on SG advice, that a particular law isn't defensible or intervention isn't appropriate.
And they also inform the court about policy implications.
Yes, that's part of the role too, helping the judges understand the potential real-world consequences of their decisions.
So ultimately, they advocate for government interests, often defending government power, but they also have to advise on conflicting principles. And the final political decision rests with the Attorney General.
That seems to be the ideal model, yes. The SG provides the expert legal input, considers all the angles, including those core principles, but the AG, as the accountable minister, makes the final call on how to proceed.
Right, let's talk about getting people into this job. Appointment, tenure, and those independent safeguards. It sounds like finding candidates hasn't always been easy.
No, the sources mention challenges back in 1969 after Sir Harry Gibbs, who was then Justice Mason, retired from the role. And also in South Australia, John Doyle was initially hesitant.
So what do? Adjust pay and pensions?
Seems so. Trying to make the package competitive enough to attract top legal talent away from potentially much more lucrative private practice.
And some states, like Queensland and WA, even offered private practice rights as an incentive.
Yes, that was another lever they tried, again, specifically to attract senior counsel who might not otherwise consider the role.
What about the Northern Territory's closed appointment system? That sounds a bit unusual. Does it raise concerns?
Well, the argument for it is that it allows for discrete checking on suitability, ethics, etc. But the obvious risk is that it could make the process more vulnerable to political influence, less transparent. It potentially undermines that perception of independence.
So ultimately, the character of the person appointed is key.
Hugely important. Many participants in the research stressed that the professional qualities, ethics, and experience of the actual appointee are the most crucial safeguards for independence.
Are there external supports for independence?
Patrick Keane, former QL SG, mentioned the Standing Committee of Solicitors General, the SCSG, and the courts themselves as playing a role, a kind of peer support and judicial oversight.
But the SG in Australia doesn't have the power to make binding decisions against the government, right?
No, not in the sense of overriding the elected government. They work with government. The key seems to be maintaining professional distance, avoiding getting caught up in the government's internal ethos, so the advice stays objective.
And we're seeing more formal processes for advice now, AGs being kept in the loop.
Yes, a trend towards more formal systems, notifying the AG when advice is sought, less ad hoc.
There's this interesting tension described, the SG as an autonomous expert versus a team member. What's the significance of that?
It's about effectiveness versus independence, perhaps. The autonomous expert might give fiercely independent advice, but maybe be less influential internally.
Right, potentially ignored.
Whereas the team member might be better integrated, more effective at ensuring legality within government, but maybe faces more pressure to conform. Finding that balance seems crucial.
And there's not much research on government lawyers generally in Australia.
Apparently not. The source suggests potential reforms, like maybe requiring the SG to be briefed on certain big issues, like the U.S. model with the OSG.
But that would be hard to define. What issues qualify?
Exactly. And there's the practical reality that the Crown Solicitor often acts as the initial filter anyway. It's complex.
The sources we've been drawing on clearly involved quite a bit of research. Can you briefly touch on the methodology? How did they gather this information?
It seems the core method was semi-structured interviews. They spoke to a wide range of people, former and current SGs, attorneys general, judges, academics, senior public servants, both state and Commonwealth.
So, talking to the key players.
Yes, exactly. The source notes it wasn't aiming for a statistically representative sample, but more about identifying the existence and range of different views and experiences concerning the role. The acknowledgments list quite a few names.
Well, this has been incredibly insightful, a real deep dive into the Solicitor General role. Just to recap some key things. We've seen a long historical path from England to a distinct Australian model.
Yes, and that constant tension, that balancing act between independence and serving the government of the day.
The dual roles advisor and advocate, and how crucial the individual's integrity and judgment are.
Absolutely. What strikes me, perhaps, is just how much influence the office can have, often quietly behind the scenes, and also how complex maintaining that independence really is in practice.
So a final thought for our listeners to chew on. Given this unique, evolving position, how might future political shifts or new legal challenges continue to shape the Solicitor General's role and its real impact on how Australia is governed? Think about those tensions and safeguards we've discussed.
It's definitely worth reflecting on. And we encourage you, if this has piqued your interest, to look deeper into the source material or explore public law more broadly.
Thank you for joining us for this deep dive.